Jim Obergefell and John Arthur were in a relationship for 21 years when the Supreme Court struck down part of the Defense of Marriage Act in U.S. v. Windsor of 2013, giving same-sex married couples federal benefits in the states where such unions were legal. John had been diagnosed with ALS back in 2011. By 2013, he was completely bedridden. Wanting to make the most of the time they had left, they boarded a plane from Ohio to Maryland where they could be legally married. When they returned home, they learned that Ohio's ban on gay marriage meant that the state would not allow Jim to be named John's surviving spouse when he passes. On July 19, 2013, they sued Ohio to recognize their marriage on John's death certificate. Judge Black held that Ohio's refusal to recognize same-sex marriage performed in other states violates the due process and equal protection rights of those married couples, and was therefore unconstitutional. He prohibited the state from enforcing the ban on the plaintiffs. Hodges, the director of the Ohio Department of Health, filed an appeal to the Sixth Circuit Court of Appeals, who reversed the decision. Obergefell then filed a petition for writ of certiorari with the Supreme Court. On January 16, 2015, the Supreme Court issued an order granting certiorari and agreed to hear the case. The case brought up two constitutional questions. 1. Does the 14th Amendment require a state to license a marriage between two people of the same sex? 2. Does the 14th Amendment require a state to recognize a marriage between two people of the same sex that was legally licensed and performed in another state? The answer was yes and yes. On June 26, 2015, the United States Supreme Court ruled in a landmark decision that the 14th Amendment required all states to license marriages between the same-sex couples and to recognize all marriages that were lawfully performed out of state. Justice Anthony Kennedy delivered the opinion of the 5-4 majority. The court held that the Due Process Clause of the 14th Amendment guarantees the right to marry as one of the fundamental liberties it protects, and it applies to same-sex couples just as it does to opposite-sex couples. The Equal Protection Clause of the 14th Amendment also guarantees the right of same-sex couples to marry, as the denial of the right would be denying them equal protection under the law. The majority also held that the First Amendment protects the rights of religious organizations to adhere to their principles, but it does not allow states to deny same-sex couples the right to marry. Dissenters argued that because the Constitution does not address same-sex marriage, it should be up to the states to decide whether or not to grant such unions. They also argue that the 5 justices stretched the 14th Amendment too far, and that it should be the elected state legislatures deciding on same-sex marriage, not the unelected judicial branch. Despite the backlash and resistance of some local governments following the ruling, gay marriage is now legal and recognized in all 50 states.